Hello, everyone. I'm Vince White. I'm an employment attorney. And today we're talking about how you can break your own attorney client privilege. And I don't mean break it like you divulge something that you shared with your attorney. What I mean is when you can kind of destroy that confidential bond, the protections you have because of attorney client privilege, where the other side can't call your attorney on the stand to testify, right? They can't get the things out of your attorney that you share to your attorney. It's very important. It's a very key part of the attorney-client relationship. And I think it's important for folks to know and understand. Let's play a hypothetical. If you call up your attorney and you throw the attorney on speakerphone and you have a long conversation with the attorney, but your cousin, who's not your accountant and not your attorney and not your spouse, presumably, here's the whole conversation, guess what? There's a good chance you're not going to be able to apply attorney-client privilege to that conversation. Why? Because someone who wasn't you or your attorney, or someone you have a reasonable belief that you'll receive confidence from, that your statements will be held confidential and protected, someone who doesn't fit in that category heard the entire thing. So, one, they can be asked about the conversation. There's lots of objections. There might be hearsay objections and everything else, but you're not going to have a lot of success with a attorney-client privilege objection, right? Two, well, you must not have thought that you needed confidentiality during that conversation, because you let a party hear it who you knew you didn't have attorney-client privilege with, right? So it's worth noting, and this is something that happens a lot, right? The client calls up and talks to the attorney, and then wants to have a confidant, a non-spouse confidant, listen in the conversation. And the attorney might say, "Oh, you can't really do that because then we're not going to have attorney-client privilege." So some clients say, "Sure thing, attorney," and then they just don't tell the attorney that they have another person listening. Not great. Not great. Because if that comes out later, well, that conversation, it's going to have fewer protections than your other one-on-one conversation with your attorney. And you don't want that. You don't want your communications with your attorney ending up as evidence. That is almost never going to be ideal for your case. In this field or any field, right? You certainly, if you're hiring a criminal attorney and you're fighting some criminal charges, you probably don't want the DA to get a hold of your conversations with your attorney. I'm betting that's not going to be an ideal situation for you, right? So this is something to think about. There's certainly other ways that attorney-client privilege can be attacked. There's other things to think about. This is just one of the most common that I see, and it's something where you need to have this conversation with your attorney, so you understand. So you're not doing things like ignoring the attorney's advice, like, hey, don't have random third-party people on the line when you and I talk, and then not tell me about it, because that's going to be a risk and a danger. Listen. And if you don't really agree with the attorney or don't understand, have a conversation. Oh, hey, why is that bad? Oh, okay. But I really want this person's advice. Okay. I mean, have the conversation with the attorney. Maybe there's something they can do. Maybe there's a way some way of having the communication or some way of sharing information with this person that doesn't violate your privilege, right? The goal is not to keep you from talking to the people you trust, who give you advice, who help you think about things, who help you discuss things out. That's not the goal. The goal is to protect attorney-client privilege.